Hello landlords, it's Ernie, I'm back, and today we're talking all about the latest court opinion striking down the CDC Eviction Moratorium Order. Let's get started. I know many of you enjoy the videos we produce. Please click like and share whenever you can. If you have a comment, please leave it below, and if you haven't subscribed yet, please consider subscribing. So we spent a lot of time discussing the CDC Eviction Moratorium Order and what courts have done since the order has been in place. Some courts have maintained its constitutionality. Other courts have challenged the order, stating that it is unconstitutional as applied. Today we have an opinion from a D.C. federal court that strikes down the order entirely. Judge Friedrich sums up her opinion as such. The Public Health Services Act authorizes the department to combat the spread of disease through a range of measures, but these measures plainly do not encompass the nationwide eviction moratorium set forth in the CDC order. And while the court acknowledges the threat of the coronavirus and the impact that it has had on this nation, what the court is set up to address isn't that impact or isn't the severity of the virus. Instead, the court only had one job in reviewing this case: to determine whether or not the CDC had the authority to act under the grant of power given to it from Congress. So the plaintiffs who brought this case were owners of residential property leased to tenants who had stopped paying rent on the basis of the CDC's eviction moratorium order. These landlords filed suit in federal court challenging the reach of the CDC and whether or not it had the legitimate authority to ban evictions nationwide. So prior cases had determined that the CDC eviction moratorium was unconstitutional. Out of the Sixth Circuit, the Tiger Lily case concluded that the CDC order exceeded the statutory authority of the Public Health Services Act. And in that case, the court denied the stay requested while the matter was appealed up to the Court of Appeals. Additionally, in the Turkle case, the federal court stated that the federal government lacks the constitutional authority altogether to issue a nationwide moratorium on evictions. That decision was also appealed, but neither of these decisions struck down the order altogether. As such, the federal district court in the District of Columbia took on the issue based on this filing. Essentially, the court undertook three specific questions. The first is whether the relevant statutory language addresses the precise question at issue. The court reviewed the language of the Public Health Service Act to determine whether or not what Congress had allocated in terms of authority applied in this case to the eviction moratorium order. The court reviewed the precise language found in section 264 subsection A of the Act to address whether or not any regulations enacted pursuant to that section must be directed towards specific targets found to be the sources of infection. In determining the extent of the authority of the CDC, the court examined three principles. The first is that courts must give effect, if possible, to every clause or word of a statute. This illustrates that the specific wording used by Congress will either broaden or limit the authority that it gives to an agency in a statute like this. Next, the court will construe a statute to avoid serious constitutional problems unless such a construction is contrary to the clear intent of Congress. Here the court means to figure out what it is that Congress intended and to not take things beyond that measure or not far enough to accomplish the goals that Congress set out in enacting such a statute. And third, the courts expect Congress to speak clearly if it wishes to assign to an agency decisions of vast economic and political significance. In other words, if Congress means to give far-reaching authority to an agency, the language in the statute should express to what extent Congress intended that reach to go. And in the 20-page opinion issued by the court found that, in fact, the CDC did exceed its constitutional authority, and in establishing an eviction moratorium, it went farther than what Congress otherwise would allow. The attorneys for the government seeking to uphold the CDC eviction moratorium essentially said, well, Other parts of the rules set up by Congress allow for quarantining, particularly when people from outside of the country attempt to enter, that Congress essentially allowed the CDC to prohibit those persons from entering the country. But the court states that that argument doesn't really hold water in comparison to what is being requested of the authority in the CDC Eviction Moratorium Order. Specifically, the quarantining provisions are structurally separate from those out of the particular section that the CDC relies on in order to explain its authority to enact an eviction moratorium. In fact, Section 264A is concerned exclusively with property interests and not quarantine. So because this court disagreed with the CDC eviction moratorium and that the CDC even had the authority to issue that order, the court vacated that order and stated the following: when regulations are unlawful, the ordinary result is that the rules are vacated. The CDC order must be set aside. And that's what this order has essentially done. So what is it that the government seeks to do? Well, naturally, they have appealed this order, and they're seeking, as in other cases, to abate the enforcement of this order while the matter is on appeal. That stay would prevent other courts from essentially disregarding the CDC eviction moratorium whole cloth. But if that stay is denied, then the order itself is unconstitutional and inapplicable in any court. Now, for those of you who are watching from a jurisdiction where a state or a local order has instituted a moratorium, the effect of this opinion will not reach you. If your state or local jurisdiction have in place its own moratorium, this order would not affect it, because this is specifically limited to the authority of the CDC Eviction Moratorium Order and would not affect anything on a state or local level. However, if the only moratorium in place is the CDC Eviction Moratorium, by virtue of this order, that moratorium has ended. Naturally, this is brand new and nobody is certain what will happen tomorrow. What we do know is we have another court striking down this order with the most severe blow so far to the CDC eviction moratorium. Will this end the argument altogether? Probably not. But is this a good first step in finally ending this unlawful moratorium? We will know more over the next few days as the government's attorneys push forth with their appeal of these decisions and landlords head into courts beginning tomorrow on the grounds that the CDC eviction moratorium order has been vacated. We'll see how state and local courts respond to this opinion. I continue to have my finger on the pulse, and I continue to dig up as much information as I possibly can to share this with you so that you make the most informed decisions when it comes to your rental property. I come to you every week with new content having to do with landlording and the law. I look forward to seeing you again sometime soon. Until then, happy leasing. If you enjoyed this video, we invite you to like and subscribe. Follow our links to even more great content. We're always adding to this collection. If you have a video topic you'd like to see, comment below.